Hearing the appeal, Miller and another against Miller and another.
Yes, Mr. Brown.
Please, my lords. I appear for the appellant and my learned friends, Mr. Michael Hilton, Queen's Counsel, and Miss Melissa MacLeod for the respondent.
Thank you very much. You may take it that we've read the papers very carefully and very familiar with the background, so you won't need to dilate on the facts to any significant extent because we've read all of the relevant materials.
Very well, my lord. May I ask you that I would start by looking at the issue as to whether the learned trial judge was wrong on the 3 areas of facts
Yes.
that the Court of Appeal so found. In the first place, submissions, my lord, is that at paragraph 4 of the judgment, the learned trial judge said that there is no dispute that it was Mr. Miller, I've added that, who purchased the property at Yardley Chase, did the actual purchase and obtained title in both names, and that he assisted in the actual construction of the hotel. In the Court of Appeal, my lord, the Queen's Counsel submitted that that is in fact incorrect. I wish to submit, my lord, that it isn't incorrect.
Yes.
Having regard, if what the judge says is properly understood.
Yes.
I understand the Court of Appeal to be saying that the error lies in the reference to the phrase, no dispute. But, my lord, if we look at the evidence, which I invite you to look at, just briefly for this particular point, and I'll just simply refer to it at evidence of Mr. John Burton, who was the vendor for the property, and it is at page 167, paragraph 3. And he said, after talking with Maggie about the land, I next talked to one Andrew Townsend.
What page did you say?
Page 167.
Which I think I've got that.
There are several which are missing.
Very indulgence.
There is a problem, Mr. Bram, about this bundle, and that is that pages 68 to 75 are missing. Pages 164 to 179 are missing. And between 304 and 305, there are 4 pages of the Connecticut transcript 1 December 2008 missing. So that's not good.
Well, may I start with the latter part? First of all, I apologize for the state of play. And in relation to the notes from the Connecticut hearing, I believe that was missing from Jamaica as well. It was not before the Court of Appeal, and I certainly, when I came in the matter, could not locate it. The rest of the bundle ought to be here, though. May I take a moment, my lord, and speak?
Just before you do that, can you tell me which paragraph? It's Mr. Burton's affidavit you were referring to, is it?
Yes, sir. At paragraph 3.
Paragraph 3.
Yes.
Right. But perhaps you can take instructions from your solicitor.
Very well, sir. I'm grateful.
It's on the E version. Is it on it?
Well, I don't know.
It's on the.
It's on the screen.
What page number is it?
It's 167.
This is complete. In fact, it's a long point. The judge got it right. In fact, this one.
The judge did get it right.
He got it.
Would have appealed wrong to say he was wrong.
She went wrongly. She or he.
You can probably share if you've got.
When he talked.
Yeah,
There's nothing.
What page are we looking at? What paragraph are we looking at?
Well, Mr. Brown, we don't want to spend a lot of time on this. It is actually on the electronic bundle I don't know why it's missing from the hard copy. And I think it may be possible for my lords to share the electronic bundle. So if you proceed to make the point that you wanted to make about paragraph 3 on page 167.
Very well, I'm grateful.
Yes?
So that it says, after talking with Maggie about the land, I next talked to one Andrew Townsend. After that, I talked with Harold Miller, who had come to do the business of buying the land. This was in January 2004. The land is at Yardley Chase, Southfield, in the parish of St. Elizabeth, about 4,365 square meters. I sold the land for $75,000. That was the price that was agreed.
750,000, is it?
750,000, beg your pardon.
Right. Well, what
Then-
point do you want to make about that?
There are just two other pieces of evidence I wish to draw your attention to. The point I want to make, though, is that when you look at the judgment, it is clear, and I so submit, that the judge was in fact referring to the person who carried out the transaction.
Person who handled the negotiations
Handled-
rather than the person who produced the money.
Paid the money.
Got it.
That's what I am saying.
Yes. Well, I think we've gathered that from your printed case in any event, so.
Very well.
Yep.
And so, just for completeness, Mr. Burton, at page 190, in cross-examination, he said, I gave, page 190,
Yes?
I gave common law title for land. I sold Canute Harold Miller for 750,000 Jamaican. He gave me cash, which I put in the bank. I sold land in 2004. I sold him one piece of land. Then at paragraph, at Mrs. Miller, Millard, gave in her witness statement at page 81,
Yes?
paragraph 9, she said, when Maggie told me he had found a piece of land, I asked my cousin Andrew Townsend to go and look at it for me. He gave me a favorable response. Based on his advice, the respondent and I agreed that he would go to Jamaica to verify that the piece of land was indeed suitable and then complete the transaction, as I was unable to go due to my work commitments. I gave him the money to cover the cost of buying the land to the respondent when he went to Jamaica to conclude the purchase.
Mr. Braham, it may be that the identity of the person who did the negotiations for the purchase on behalf of the parties may not be all that important.
Well, the point is that the judge didn't make the mistake that the Court of Appeal thought he'd made. He was actually, isn't it? He's simply saying that the person who handled the negotiations was the husband. And if you look at paragraph 5, he expresses return to the fact that there was a dispute about the source of the money.
And that's the submission I wish to make, that the Court of Appeal was wrong, and I don't think I need to belabor it.
No.
To accept that. I think that is clear. And in any event, my Lord, I wish to point out that the dispute, the phrase, no dispute as to who, if those two words were removed and the judge had in fact found that it was Mr. Miller who had in fact paid the purchase price, there would be evidence before the court upon which it could have so found, because Mr. Miller, in his witness statement and cross-examination, insisted that he was the one who provided the purchase money. But that's not the point at this stage. At the end of the day, I am saying that the Court of Appeal was wrong to have found that the judge made that error.
Could you go to paragraph 11 of the judge?
Of the judgment.
Page 238.
Says, my Lord,
What did the judge mean by his procurement of the land?
to my mind, my Lord, when you read it in context, procurement of the land, especially when you see the second phrase that come after it, simply mean the transaction.
I see. Right.
If I then move to the second purported error, And that, my lord, has to do with no legal representation. And indeed, my lord, I can say at this point that in fact, in the United States, Mr. Miller did have legal representation, and so did Mrs. Miller. Mrs. Miller, of course, was blessed with the additional benefit of having a Jamaican lawyer. But, my lord, well, I think no legal representation is actually the third error, but I just finish it instead of the second. But, my lord, my submission is that, in fact, this is not a material error. And I raise that, my lord, in the context that, one, the judge mentions it, and no further reference was made to it in his brief judgment. But more importantly, my lord, I ask you to have a look at Section 10 of the Property Rights of Spouses Act. I will hereafter refer as PROSA, page 929. My lord, you will see, my lord, that at section 10(1)(b), page 935, I should say, I'm sorry.
Yes.
That it allows the parties to a union or marriage to enter an agreement to settle their differences. And then, my lord, section 10, subsection 3, page 936, you will see, my lord, that agreement, the parties are required to have legal advice. Then, at section 10(5), the agreement is unenforceable if there was no independent legal advice or it was unjust to give effect to the agreement. I submit, my lord, that the judge did not, in fact, invalidate the U.S. agreement. That the finding as to an attorney in the United States would only be of value if the validity of the U.S. agreement was called into question. It was never called into question. The judge accepted it, relied on it. So he did make an error, but I submit to you, sir, that it was not a material error.
Yes.
The third point, my lord, has to do with the evidence given by Mrs. Miller's nephew, I think, cousin, Mr. Townsend. Mr. Townsend.
Yes.
And that, my lord, you'll recall that Mr. Townsend, the judge said that Mr. Townsend gave evidence that Mr. Miller, the appellant's business, far exceeded that. I was far superior to that of his uncle, Mr. Townsend. The evidence given by Mr. Townsend did not actually say that. But the Court of Appeal itself, my lord, did not apply any particular importance to that error. And you'll see that, my lord, in the judgment of Mr. Justice Brooks at page 332, my lord, and Lordship said, crave indulgence, yes. His Lordship says, my lord, at paragraph 28, despite the error, there was other evidence that supported the learned trial judge's conclusion on this point. For example, Mr. Miller at page 6 of his witness statement said, Mr. Miller's uncle, Errol Townsend, is a body repair man of modest means who always alluded to have insufficient resources.
Which paragraph are you reading from?
I'm reading at page 332.
Okay, thank you.
And at paragraph 28.
Thank you.
So it says, despite the error, there was other evidence that supported the learned trial judge's conclusion on this point. For example, Mr. Miller at page 6 of his witness statement said, Mr. Miller's uncle, Errol Townsend, is a body repairman of modest means who always alluded to having insufficient resources to meet his obligations. He then went on to give examples of Mr. Townsend having been taken to court by 2 different women for child maintenance. Mr. Miller at page 4 of his witness statement addressed the capacity of his own operations. He said, the construction of the hotel began in or about March 2004 and was funded primarily from the income that I obtained from operations of my garage and from the restoration and sale of damaged motor vehicles. He said that Mrs. Miller's financial contribution was no more than $20,000. Based on that analysis, it cannot be said that there was no basis upon which the learned trial judge could have arrived at that conclusion. And so, my Lord, I am submitting to you that the error or errors highlighted are not proven.
But Mr. Bram, leaving aside whether there was evidence to justify the conclusion that your client's auto business was vastly superior to that of Mr. Errol Townsend, if I may put it this way, so what? Where did that leave anybody? I know the wife was alleging that she obtained a loan from Mr. Errol Townsend, which went into the hotel. But simply to say that the husband's business is vastly superior to Mr. Errol Townsend, that's not to say that she didn't get a loan from Mr. Errol Townsend.
He expressly rejected that, my Lord.
Well, that's the trouble, isn't it? The judge seems to have relied on Mr. Andrew Townsend's evidence as part of the reason why he rejected the wife's contention, the wife's evidence about where the money came from. And to the extent that he's got Mr. Andrew Townsend's evidence upside down, is that a material error, perhaps?
I would say, my Lord, if you are required to look at the evidence as a whole, and having regard to what the Court of Appeal has highlighted, then it would not be a material error.
Okay.
That's how I would respond to that, my Lord.
Yes.
And so I say that, notwithstanding that he got it wrong in terms of what Mr. Townsend, the nephew, may have said, that in the end, he had evidence upon which he could rely. The Court of Appeal itself did not seem to find this a problem. And I say, my Lord, that having regard to all the circumstances, I submit to you that the findings by the Court of Appeal is not justified. I then move to the next set of points.
Yes.
Are you going to move to whether there was another error, Mr. Bram? Mr. Justice McIntosh said, in that agreement, that's the Connecticut agreement, the claimant got all 3 properties in the United States of America, absolutely. All 3 properties, Mr. Brown?
My Lord, in relation to the properties, there was one property that Mr. Miller got. Then, my Lord, there were 2 other properties that she got, those that were owned jointly, my Lord. But you will note in the evidence that there was a 3rd property. That property, my Lord, was owned by, the title anyhow, had the names of Mrs. Miller and her brother. Mr. Miller's evidence was that at the time it was put in the brother's name because his legal status in the United States was unsettled. The Court of Appeal itself said, my Lord, that the property, even though not in Mr. Miller's name, under the laws in Connecticut, was to be taken into account, my Lord. So when the judge said all 3 properties, I submit that this 3rd property is to be taken into account. I will try and find this statement by the Court of Appeal.
Which is the one you're talking about?
Paragraph 51 is...
No, which property?
Lilac Street, I
Lilac
presume.
Street, isn't it? It's Lilac Street, isn't it?
Yes, sir.
Yes, but the one that the husband got is Tower Avenue, which is where his business was, isn't it? Yeah. Well, I think the problem is, or at least the suggested problem is, that Mr. Justice McIntosh seems to have overlooked that.
I wouldn't say that, sir. The property, I would say that the husband got the business place.
Where did Mr. Justice McIntosh say that?
He didn't expressly say so in the judgment.
He didn't refer to it at all, did he?
No, my lord.
Oh. Well, that's the point that my Lord is making to you. Leaving aside the explanation that you have offered for the avowed mistakes, this was a mistake on the part of the judge that was material to his decision, wasn't it?
It would be material, if it is, my lord, that you find that it is a mistake. And of course, this mistake was not referred to by the Court of Appeal itself as a ground upon which they purport to set aside his findings. But I would urge, and I think that if I'm correct, that the third property, which was owned by Mrs. Miller, and in the name of Mrs. Miller and her brother, which is on the evidence, which the Court of Appeal...
Well, I don't think they were too concerned about that. It's the omission of any reference to the property which Mr. Miller unquestionably did get in America.
Yes.
Because the flavour that one gets from Mr. Justice McIntosh's judgment is that the husband got really nothing from the case in America, and that therefore that affected his decision as to the disposition of the property in Jamaica. Now, if that is right, if that's a proper characterization of his judgment, when one comes to discover that indeed the husband did get a property, presumably a fairly valuable property, because it's where he carried on his business, then one has to question whether the judge, Mr. Justice McIntosh, was entitled to reach the conclusion that he did about the disposal of the property in Jamaica.
The response that I give to you, sir, concerns, the only response in the circumstances is that when the judge referred to three properties, that he was taking into account the third property, as I pointed out, that was in the name of Mrs. Miller and her brother.
Yes, but that isn't really relevant to the point that is being made. It doesn't matter about the third property that went to Mrs. Miller and her brother. The fact is that he didn't refer to, presumably, an extremely valuable asset to Mr. Miller, namely the property where he carried on his business.
He didn't refer to it, my lord, expressly. Unfortunately, the judgment is fairly succinct.
He didn't refer to it at all.
He did not refer to it. But is that to be interpreted to mean that he did not have it in his mind?
Well, it's very difficult to square that with a statement that the wife got all three properties.
Yes.
Was there a mortgage on the property that your client got?
No, my lord, not as far.
Was there a mortgage on all three of the American properties that the wife got?
Yes, sir.
Yes, well.
My lord, I don't think I can take that
No, I think you've dealt with it as best you can, yes?
in the circumstances.
Yes.
Safe to say that that point, as I pointed out earlier, was not of importance to the Court of Appeal because they didn't refer to it in particular. So, my lord, assuming that the Court of Appeal was correct, the question that I wish to ask your lordships to consider is whether or not they handled the law properly. I submit, my lord, that they did not. And I would, for that purpose, take you to PROSA itself as a backdrop.
Yes.
And that, my lord, is to be found at page 929. crave your indulgence.
Yes. Which section, please?
I will start, my lord, with the section 2,
Section 2.
which is the interpretation section at 931.
Yes, thank you.
And so, my lord, you will see in section 2 that the first issue, my lord, is the question of a definition of spouses. And that definition is at page 932. A single woman who has cohabited includes a single woman who has cohabited with a single man, etc., etc.
Yes.
That's the first point. So therefore, it is the law is covering in a wider group of persons apart from married couples. Then, my lord, if you look, and then of course there's a definition of cohabit at page 30.
Is there any dispute about this?
No, my lord. I will move along.
Yes.
Then, my lord, I ask you to come to section 4,
Yes.
which is of interest, at least to me.
I'm sure it'll be of interest to us as well.
So just in a sentence, what are you getting out of looking at this statute?
Well, my lord, what I am saying is that you will see that the Court of Appeal, in dealing with the matter, referred to the English Matrimonial Causes Act 1973 and the cases that surround it. And then you will see that he accepted the provisions, a statement in White and White, which dealt with equality, which, of course, the House in White and White said was to be treated as a yardstick. And therefore, as I understood the judge, that you departed from equality only if you have good reason to do so.
Well, your point is, isn't it, that instead of being driven by the English jurisprudence, the Court of Appeal should have concentrated on proso.
That's what I'm saying, sir. And to my mind, particularly having regard to the legislator seemed to have gone out of his way at paragraph 4 to say that the provision of this act shall have effect in place of the rules and presumption of the common law and equity to the extent that they apply to transactions between spouses in respect of property, and in cases for which provisions are made to this act between spouses and each of them. And then, my lord, interestingly enough, section 3.1 sets out circumstances where those same rules may apply. Section 3.1 is at page 932. Except as otherwise provided in this act and subject to subsection 2 and 3 and section 6, the provisions of this act shall not apply after the death of either spouse, and every enactment and rule of law or of equity shall continue to operate and apply in such case as if this act had not been enacted. So I think, my lord, it does demonstrate a clear determination by the legislature to say, follow this act.
Yes.
And my simple point is that the judge followed the equality principle and then went through the evidence to see if there would be any justification to depart from it.
Yes.
So wrong to apply the English cases, and especially White. And I think in your written document, you also say wrong to treat it as depending on the common intention of the parties when they acquired the property, because that's what's overruled, as it were, by Section 4.
Indeed.
Okay, thank you.
And that is a very elegant summary of what I was about to say, my lord. But
On that point, Mr. Bram, I wonder whether we could go to page 53 of the bundle. This is your client's statement of the 15th September 2011 couple of months before the hearing before Mr. Justice McIntosh.
Yes, sir.
Third line, on 30th January 2004, the vendor issued a receipt in the joint names of the claimant and I, as I directed him to do. At the time of acquisition, it was intended that this property would be owned by us equally. As far as I was concerned, although the claimant made no contribution towards the acquisition of the property, I intended her, as my wife, to benefit equally. In those circumstances, there was no need to look for presumptions, and there was no need, surely, for us to be considering whether it was right or wrong to look for presumptions. Your client has said, in terms, the intention was equal beneficial ownership.
Yes, he said that. And my response to that, in the context of this appeal, that indeed, if you look at it as a factor to be considered, it is indeed, when you look at all the factors set out under PROSA, it is a factor. But what has happened in this case, when it is elevated to a special status, where everything else is looked at as to whether or not it could be used to set it aside, I think that's where the error is. If the judge at the Court of Appeal had in fact put all the issues in balance without saying that we are starting from this yardstick position, then I could have no complaint. But to my mind, that's not what they did. They simply started out and took the easy way out, and then say, these are all other matters that suggest that we are right to take this easy way out. I can't take it any higher, but I think it is fundamentally wrong, my Lord, for the Court of Appeal to have done that, and indeed it is in fact legislating when it ought not to do so.
What is it about PROSA which you say would have dictated the outcome that Mr. Justice McIntosh arrived at?
My Lord, the judge and the Court of Appeal mentioned it, took into consideration his involvement in the construction, which is a PROSA requirement, took into consideration...
Which specific provision in PROSA?
Very well.
You say justify the judge's conclusion?
Very well. I'll bring it to your attention. I crave your indulgence. So that the first section, page 940, section 14,
Yes.
my Lord, and you'll see at 941 the factors. It says contribution, financial or otherwise, directly or indirectly made by or on behalf of the spouse to the acquisition, conservation, or improvement of the property. And then of course, contribution is elaborated in in subsection 3.
But before you get to subsection 3, there's paragraph D of subsection 2, that there is an agreement with respect to the ownership and division of the property.
Yes, sir. But that agreement only covered the U.S. properties.
Yes?
It specifically reserved determination as to the Jamaican property, meaning Yardley Chase.
But what about the original agreement about the ownership of the Jamaican hotel?
That Mr. Miller spoke about. Indeed, that's a factor that I agree ought to be in the mix.
Okay.
It is to be in the mix. But as I explained and submitted earlier, that it wasn't treated as a matter in the mix, but treated as a test as to whether or not the starting position was correct.
Is this part of your submission, which is the criticism of the Court of Appeal's approach, is it one which only arises if, as it were, you fail to persuade us that the Court of Appeal shouldn't have been redoing the exercise at all?
That is my alternative position, that I must confess that the learned trial judge's judgment is brief and probably ought not to be so brief, if I put it that way. And therefore, there are many issues that there were no comments made on. And without hearing the evidence, and you see in the evidence that in the papers that the learned trial judge, having seen the witnesses, seemed to have taken a strong, should I use the word, dislike to Mrs. Miller.
Yes.
In other words, he did not accept her. But a lot of the factors in the case has to do with who do you believe and who do you don't believe. And to my
You say
mind,
really it comes down to the financial contribution made by Mr. Miller. That's the pivotal factor in section 14. Is that what you're...
that is a critical factor, but there's no finding on it, either because, of course, the Court of Appeal set aside Mr. Justice McIntosh's position, and, of course, both of them claimed that they entirely financed the purchase and substantially financed the building of the hotel. And to my mind, my lord, how do you, without hearing the evidence yourself and seeing the witnesses, make a determination on that fundamental issue?
Mr. Braham, your predecessor in the Court of Appeal, Ms. Shaw, was obviously primarily contending that Mr. Justice McIntosh's judgment was correct,
yes,
and that the appeal should be dismissed.
Yes.
Did she, in the alternative, say that there should be a remittal of the matter to a different judge to be reheard for findings to be made?
On my review of the paper, sir, I didn't see that.
Well, if you don't succeed on your first argument, are you not driven to invite us to remit the case?
Indeed, my lord, I would be suggesting to the court that that would be an appropriate measure to be taken in this case, because the factual situation do require canvassing and findings, my lord, and I personally wouldn't say that that was satisfactory, that all the issues were dealt with and so on. And I don't think that the Court of Appeal itself...
The findings as to the financial contribution that each claims to have made. Anything else?
Well, that is important, my lord, because Prosser expressly mentioned that,
yes,
as important. The whole question as to whether or not Mr. Miller was involved in the construction and managing the construction, and then when the hurricane came and destroyed the property, his involvement, and indeed the whole question as well as to the monies, where did he get the money? The Court of Appeal took the view that he must have gotten it from the hotel. But he gave evidence, and mentioned by the Court of Appeal, that the hotel was not doing well because of poor road condition, downturn in the economy. He could not advertise it because people wouldn't drive there, and so on.
Well, I just want to get an idea of what is the range of factual findings that you say requires to be made.
The first one has to do with the contribution.
Yes.
And because Section 14 of Prosser says that, my lord, the contribution, financial otherwise, directly or indirectly.
I think we've got contribution. I'm really hoping to get from you any other...
yes, my lord, the whole question of improvement and conservation of the property, which would then come into the fact that the property was destroyed in the hurricane.
Practical contribution is distinct from the original financial one.
Yes, sir.
Yep.
The hurricane was a problem. There was evidence that the accounts of the hotel was frozen at a point. And so the evidence is that he was involved and was principally responsible for its rebuilding, and further, that he constructed a dwelling house on the property. Yeah. Those are matters, to my mind, that required canvassing. But even if I wasn't able to go to the others, the first point of the contribution, to my mind, and I recommend and submit to you, is of fundamental importance.
Yes. Very well.
My lord, I just want to point out one other thing.
Yes.
the learned trial judge referred to section 15. And I pointed out for two reasons. One, because I think he was wrong, and two, if the court is in a position to make some sort of pronouncement on section 15, it would be useful. Because there is some dispute, certainly practitioners in the family law division, as to how section 15 is to be used as it interplays with section 14.
And section 13.
And 13.
Who do you say referred to it, Mr. Bradley? It's the Court of Appeal, is it?
Yes, sir.
Yes.
The Court of Appeal mentioned it, if I may. When the whole question of fairness was being dealt with, His Lordship, Mr. Justice of Appeal Brooks, referred to section 15 because there is a phrase in section 15 that he thought suggested to him, I think, allowed him to take into consideration the...
Which paragraph is that?
Sorry, I crave your indulgence. Paragraph 43 at page 340. Says section 15 of PROSA is also important in emphasizing the legislation's stress on fairness. It authorizes the court to alter the interests of spouses in property if it is just and equitable to do so. And you'll see, my lord, section 15(2), my lord, require the court to make no order unless it is satisfied that it is just and equitable to do so.
Well, the language of section 15(1), which is the principal enabling section, is fairly similar, isn't it, to 14(1)(b). It enables the court to do, and in both cases, as it thinks fit.
Yes. But, my lord, the question, to my mind, and I am submitting that section 15, having regard to section 15A, B, and C, appears to be contemplating other types of proceedings. Not proceedings for the division of property, which would be the determination of interest, would come under 14. But if you have other proceedings, whether it is dealing with children, maintenance, and so on, that require the court to secure anything to any of the persons involved, then the court, using section 15, could alter the interest to meet that situation.
Mr. Bram, I'm speaking for myself. I'm very interested in what you said about some confusion or concern about the interplay between section 15 and section 13, because some of us, when we studied those sections in preparation for this hearing, were similarly perplexed as to what the juxtaposition was, as to what the difference was, as to when one section came in and when the other section came in. And you have so interestingly said that this is a matter for, at the moment, for discussion on the island. Is there anything we could read about that? Are there any judgments that wrestle with it?
I have not located any. I don't know whether my learned friend, Mr. Hilton, has found any, but it has caused a lot of search and probably consternation as to how it is to be used. Largely, it is ignored.
Section 15 is largely ignored.
That's my...
Well, section 15 is ignored, or the question of whether there's a difference between the two is ignored.
Probably both.
Probably both, yes.
Because what happened is that the judges at first instance, from the reading that I have, generally rely on section 14 and 13. That's my experience. But then, of course, section 15 is still there. And especially when you look at...
They're very, very broad provisions, aren't they? They're read together, they simply give the court a wide power to do what is fair and just in all the circumstances, don't they? I mean, that's what it boils down to.
But you see, yes, indeed, I agree. fair and just in the circumstances.
That's a very broad question for the judge of fact.
But, with respect, does that mean, because it says that, fair and just in the circumstances,
It all depends on the facts.
that Section 4, which is the one that is seeking to abolish reliance and provision, is of no moment?
Now, am I right, Mr. Bremen, in reading these sections Section 15(3)(b) brings in the variable factors from 14(2), doesn't it? So they're common to both.
It is common
right?
to both, my lord, except that, of course, Section 14 doesn't refer to Section 15.
Well, no, but you see, 14, as you say, deals with a case where a spouse applies for a division of property.
Alteration.
A division.
It says alteration.
No, 14.
14, yes.
It says division. 15 says, if you happen to have in front of you any issue about the property other than the matrimonial home of spouses, you may exercise an equivalent jurisdiction, or seems to. I think that's what you were just suggesting might be the reason for two different sections. It depends on the kind of application that somebody's made.
Yes.
Is there any other difference?
If there's any what, sir?
Is there any other difference?
I can't think of any other. It appears, of course, it refers to just and equitable, and the question that some may argue that because it is referring to just and equitable, then Section 4 is not as significant as others would suggest.
Well, why do you say that? I mean, Section 4 abolishes reliance on equity in the common law, but these sections are talking about what the judge considers to be just. There's no incompatibility between them, is there?
So long as it is interpreted as being subject to Section 4, there should be no incompatibility.
Well, you can forget about all Section 4. It says you can no longer look at the common law. You can no longer look at equity. So you forget about them, and you simply look at sections 14 and 15 and apply them to the facts. And they're very broad sections which entitle the judge to do what's fair and just in all the circumstances, as I see it.
Very well.
And that's really all there is to it. So we're back to the facts.
We are indeed, and I have in fact made my
So the case doesn't really involve any new question of principle, does it at all?
It certainly
Because
does
we can
not.
read the statute, and the statute means what the statute means, and then it
certainly does not include the principles raised under the UK 1973 Act at all.
I follow that, yeah.
And of
I
course,
suppose you can say that insofar as the Court of Appeal referred to them, it shouldn't be doing so.
and they should be corrected with respect.
Well, except insofar as those cases may give an indication of what is fair and reasonable or just between the parties.
Well, see, it would be difficult if they do in the context of the 1973 legislation. I don't accept that when you read the 73 legislation, in particular the section 23 to 25, my lord, that it is necessarily the same considerations that...
No, not necessarily, but potentially. That's the point that I was making. In any event, I think we have your argument on that,
yes.
Mr. Braham. Anything else?
I think that would be a crave your indulgence. I think that would be all.
Thank you very much. That was very helpful indeed.
Thank you. I'm obliged.
I think we better hear you, man. I think we better hear you. Okay. Now, Mr. Hilton.
My lords. My lords, if I may start with addressing the issues of fact.
Yes.
Which my friend started.
Well, you can take that fairly short compass because we've reviewed it
Yes.
fairly
Well,
extensively.
there's one matter that might assist your lordships.
Yes.
The issue was raised, my lord, as to the properties in the United States that
Yes.
the various parties received. And your lordships would have observed that none of the judgments comment on the values of the properties. But there was uncontested evidence, both as to the value of the properties and as to the amounts of the mortgages. And my lords, we have prepared a table which sets this out and where the evidence can be found.
Yes?
If I could ask that it be handed to your lordships.
Oh, thank you.
Yes.
Thank you.
My lords, the first three properties on this table are the properties received by Mrs. Miller, and the fourth, Tower Avenue, is the one received by Mr. Miller. And your lordships will see there the values, all figures in US dollars, the values both gross and net
Yeah.
of the respective properties.
Yes.
The Lilac Street property, there was no evidence as to the specific value.
Yes.
So that there is that additional evidence.
Yes.
So these figures either agreed or not disputed?
Not disputed, madam.
Where you got them from, Mr. Hill?
Evidence of Mrs. Miller,
Thank you.
So this is as at when?
as of 2008, as at the settlement agreement. And this evidence, my lord, was in her witness statement 3 months before the trial. And as the lordships would have noted, she was cross-examined at length, and this issue was not disputed at all.
Yes.
Now, my lord, my learned friend raised the question of the repairs to the property that his client did and the house that he allegedly built. And your lordships will know that the Court of Appeal took the view that to the extent that he did not pay the maintenance that he had agreed to pay, that was a factor to be weighed against his claim for a credit for doing those things. Well, my lord, there are two other factors why those things he did ought not to be taken into account. The first is that on his evidence, the only income he had at the time was from the hotel's operations. And if your lordships look at page 149 of the record, my lord. This is a motion the appellant made for alimony in January 2008. And in that motion, in a financial affidavit at 151, he claimed that his only income was from the hotel. And the point I make, my lord, that to the extent that he is using the hotel's income from the hotel's operations to do repairs and so on, they cannot be treated as inuring to his benefit so as to justify an alteration of the interest.
Yes.
And the third point, my lord, and this, I think, relates to an issue that arose in exchanges with counsel as to the remitting of the matter. There was, as your lordships have observed, not only limited findings in relation to respective contributions, but limited evidence.
Well, the
In
evidence
particular-
was in dispute, wasn't it?
Yes, my lord.
Yeah,
But
Conflicting
conflicting,
positions were taken.
yes, my lord, but also limited.
I'm sorry?
But also limited.
Yes.
And on this point, that is to say, the question of repairs, Mr. Miller, the appellant, gave no evidence as to how much he spent, what was the nature of the repairs, what was the nature of the damage. And what is significant in that regard, my lord, is that he was twice ordered effectively to give this evidence. If your lordships go to page 42 of the bundle, at page 42, there's an order made in January 2011. This trial was in November of that year. In January, at paragraph 4, the court ordered the appellant to provide an accounting of all income and expenses for the hotel from August 2007. And the period over which this order required accounting would have included those repairs, that construction.
The hurricane summer 2007.
Yes, my lord, it was. It was August 2007, so that when the order said from August 1,
Yeah.
it was just before the hurricane. Now, this was ordered to be provided by May 31. It was not. And if your lordships go to page 49, you will see that in September, the court made another order. And this now was an unless order requiring compliance with that same order by September 16. Your lordships will see from the evidence that it was still provided. And what I take from this, my lords,
And this is an unless order, is it?
it was an unless order, my lord.
So what happened then?
It was never acted upon, apparently.
It wasn't acted on.
No, my lord. The defense was never struck out. It proceeded.
But nobody applied for it further to be struck out.
Apparently not, my lord. I did try to ascertain, my lord, why, neither my friend nor I were at the trial. I did try to ascertain why not, and I got no explanation. It seems to have been overlooked.
Paragraph 1 is a bit obscure, isn't it? It's not quite clear what it really means. They say, does it mean that it will stand struck out,
Or one can have it struck out.
or whether you need some further order of the court actually to have it struck out? But in any event, the trial seems to have proceeded on the basis it was not struck out, and so there we have it.
I think, frankly, it was overlooked. But, my lord, what I take from this,
So how does this, I mean, this is a sort of never underestimate the value of a prejudice point, isn't it? I mean,
Well, what do you take from it?
I take from this, my lord,
Mr. Hilton?
that the court could not, on the evidence produced by the appellant, vary the legal interest on the basis of repairs that he had done when he provided no evidence as to what those repairs were and what those repairs cost.
Well, he didn't provide any evidence about what they cost, but he did provide, in his oral testimony, evidence about what he had done, didn't he?
Well, not as to in relation to repairs, my lord.
Yes.
Well, he just said that he had done repairs, that they had been damaged by the hurricane.
I'm sorry, say that again, please.
There had been damage by the hurricane,
Yes.
and he caused the repairs to be done.
Yes.
But as to the details, either of the damage or of the cost,
Yes.
my lord, I would say that relevant to this point also is this issue about section 15 and 15.2. And if I could take your lordships there. While I agree that there is some issue as to the interplay between the sections, section 15 does add one important thing. Section 15.2 says that if the order that the court is going to make would result in an alteration of the interest, it shall not make the order unless it is satisfied that it is just and acceptable to do so. And I think that what the effect of this section is, and what this adds to 13 and 14, is to say that the starting point is the legal interest, and a departure from the legal interest requires positive evidence by the person proposing it, which is effectively, my lord, the position taken in the English cases. So I would say, my lord, that that's what section 15 adds. And of course, one can ask why this wasn't simply added to section 14 or 13, where a whole new section was necessary. But it certainly adds that. And when one considers that in the context of the point I just made, which is to say the absence of evidence from the appellant in relation to the matters he said he did, I would submit, my lord, there was no basis on which the court.
Mr. Hilton, what about Lord Hughes's point that Section 13 requires a spouse to apply for a division of property? So there's got to be an application by a spouse. And I think Lord Hughes was suggesting that Section 15 might come in any proceedings in which the property of the spouses crops up even absent
An application.
a particular application. Do you think Lord Hughes might be right about
I
that?
think that's right, my lord. I think that is probably right, yes.
I mean, don't guess, Mr. Hill, well, I know you wouldn't, but this is April 2006, this Act, isn't it? Look at page 931.
Yes, sir.
Although the Act is described as number 4 of 2004, so maybe it first saw the light of day in, but anyway, 2004, 2006, it doesn't matter.
Yes,
it's comparatively
It
recent.
didn't come into force until 2 years after.
That's when it came into force, okay. Was it the result of any report or committee or does anybody know what the trigger was for its being enacted?
My lord, at tab 2, the decision of the Court of Appeal in Brown and Brown Justice of Appeal Morrison, whose judgment starts at page 474, spent some time starting at page 476 on the background to the Act.
To sum it up, to sum up that very useful judgment in that case, in comparison with England and Wales, where there had been property adjustment provision from 1971, you on the island were still left with the Married Women's Property Act, your Married Women's Property Act.
Model of your older Act.
Very similar to ours, and there was no wider provision. And correct me if I'm wrong, Jamaica was wrestling from 1975 onwards with what sort of property adjustment provision to make, to loosen it all up. And there were green papers and consultations and various contributions, and all this took a very long time, and the result was the PROSA. Is that right?
That is exactly correct, madam.
Yeah, okay.
That's exactly correct.
That's the answer.
And indeed, my lord, your observation about loosening it up, we made the point in our written case that the purpose of the POSA was to, as if I may use my Lord Clerk's words, give the trier of fact a wide latitude to do what he saw just based on all the factors in the case.
Yeah.
And you've got provision for cohabitance issues to be resolved in that way, whereas England and Wales at the moment doesn't.
And indeed separated spouses where there's no court order at all. Yeah.
Right.
My lord, there's an issue of law.
This is all very interesting, but when push comes to shove, we're simply construing these two sections, sections 14 and 15.
Yes.
Whatever the history of it all is, what this Act says is do away with the common law, and it's all in the two sections. And it's a broad question of the judge of first instance to decide. You don't have to fish about anymore in the history and the funny old cases about this and that.
My lord, there's an issue of law that is not fully addressed in our written case, and that is a contention raised by my learned friend in his written case as to the effect of the judgment in Lasker and Lasker on Stack and Dowden, and the point as to whether common intention arises in a case dealing with investment property. Your Lordship's Board's opinions in Marr and Colley were delivered after the written cases.
Yes.
And I would just submit, my Lord, briefly that that case disposes of that issue. A case in which I note that both Lord Newburger, who decided Lasker, and Lady Hale, who decided the leading judgment in Stack and Dowden.
Well, there was an attempt made to reconcile the
I see, and your Lordship wrote the judgment.
insofar as there are differences between Lasker and Stack.
Yes, and I think I can fairly say in summary that your Lordship's observed in that case that the principle applies in both cases, that one looks at the common intention. It's not, Stack and Dowden did not intend to say it only applied in domestic and not in investment properties. And as your Lordship have also noted, in this particular case, one hardly needs to go to presumptions as to what the common intention was, because there's direct evidence of it. There is, of course, also the fact that the title was, the conveyance was done in both names, and the parties proceeded on that basis until things went wrong.
Well, I think Mr. Braham's essential point on this is that there simply isn't enough evidence on which findings could be made, reliable findings could be made, as to A, the intention of the parties, and B, the contributions actually made by each.
Yes.
Because of the deficiencies in Mr. Justice McIntosh's judgment and the inability of the Court of Appeal to address those issues, no satisfactory findings have been made.
Well, my lord, the first question would be, was there a basis to set aside Justice McIntosh's finding of fact and approach the facts anew?
Well, I don't think we need to hear you in any
so,
detail on that.
So, my lord, and that I would say that there's plainly was such a basis.
Yes.
So that putting aside Justice McIntosh's findings, on the evidence before the Court of Appeal and before the board, is there sufficient to come to a conclusion as to what the outcome should be? I'm sorry. And I submit, my lords, that there is, because while there is not much evidence on the question of the financial contribution to the property, to the construction, because there is undisputed evidence on a variety of other issues, all of which either point to a joint ownership or point in the respondent's favor. So that the evidence as to her non-financial contribution, the evidence as to the common intention, the evidence as to the legal title, and so on, even if one were to have concluded that Mr. Miller, the appellant, made a significantly greater contribution financially, I would have submitted, my lord, that on the totality of the evidence, the conclusion of the Court of Appeal would still be right.
I think your submission really resolves to this, that whatever the omissions in the evidence, it's sufficient to constitute a requirement for the Court of Appeal to apply the starting point, and there certainly isn't any evidence, you would say, which would justify them departing from the starting point.
My lord, that would be my evidence. And when one considers that not only was there an opportunity for the appellant to provide greater evidence and greater detail, but there were orders that he do so, and that one of the effects, my lord, I should point out, of remitting the matter would be that the appellant has been in sole possession of the property now for 10 years, and sole possession of the income and so on of the property. One matter that your lordships may not be aware of, the Court of Appeal's order that directed certain steps be taken has been stayed, pending the appeal before your lordships. So that status quo has continued for 10 years and would continue into a remission. And on our submission, my lords, the eventual outcome of the case is not likely to be changed in that respect. It's one of those cases, not unusual in these matters, where the parties at the relevant time did not keep the kind of detailed accounting that persons not in that relationship would. So that some of the evidence that is not available because of the nature of the relationship and the circumstances.
I mean, you say that the analysis between paragraphs 47 onwards were open to the Court of Appeal. That's what it all boils down to, really.
At what page, my lord? I'm sorry.
Well, there's a long passage in the Court of Appeal judgment, starting in paragraph 47, where they set out, well, they first of all set out the relevant sections of the Act, as we've seen. Then they set out how they've applied the broad questions laid down in that statute to the case. And that involves a balance, a whole series of factors, and there's no basis upon which we could properly interfere with it. And that's what it boils down to.
That would be my assumption, madam. Yes,
Yes.
1 second, please, ma'am. My lords, unless there's anything else with which I could assist your lordships.
Thank you very much indeed. Ms. MacLeod? Do you wish to follow?
No.
No, thank you very much. Mr. Brad.
My lords, my learned friend, in relation to section 15, subsection 2, suggested that that is the basis for your lordship to form the view that the starting point should be the legal interest. But with respect, I submit that that must be wrong, having regard to section 4 of PROSA. In relation to LASCA and LASCA, that I agree is settled by Mar and Colley, so I need not say anything further about that. That was to be, my lord, because I was saying that even if you are going to apply pre-PROSA rules, then you would have applied the wrong one. You would have to look at the whole question of financial contribution, because the resulting trust argument would be the applicable argument being an investment property. But it does still demonstrate the importance of the financial contribution. I don't think that financial contribution can be simply ignored when PROSA expressly require it to be considered. Insofar as I ask your lordship to look at page 57. In the evidence, the second paragraph, that's Mr. Miller's evidence, and he made this statement: in August 2007, Hurricane Dean hit Jamaica and destroyed much of the guest house infrastructure. This had a further crippling impact on the operation of the guest house and my livelihood. So the point I make is, yes, there's no figure, but you will see that Mrs. Miller said that she spent $400,000 that she borrowed, plus another $300,000 US on the property. That was her evidence. And so if it is substantially destroyed, it seems to me to be reasonable to presume that the costs associated with restoration would also be substantial. That's a reasonable inference.
But it's said against your client that he could have produced a lot of material about cost, but he didn't do it.
Yes, I can't give any explanation as to that.
He thought it was in his best interest to keep it quiet. I don't know.
We don't know. That could be an inference, but it's not inexorable in practice.
Mr. Brown, thank you for that. Can we take it that you accept that your client breached the order number 4, dated 11 January 2011?
The information was not provided.
Very well, thank you.
My lord. You see, I say it that way because there could be many explanations for it. And when you put it breach, it suggests a certain amount of deliberateness and so on, my lord.
Well, in any event, the order was not complied with.
It was not complied with and it was not pursued at the end of the day, which would have been interesting that it would have brought the matter to an end if it was pursued. So that's how I would respond to my lord.
Thank you.
And then, my lord, just to add to that, my lord, that in terms of the mortgage, that there is evidence from Mr. Miller that those properties that were rented adequately covered the rent. Subject to you, sir. The mortgages, sorry.
Yes.
Subject to you, sir. That's what I would.
Very much indeed, Mr. President.
I'm obliged.
The Court is very grateful to counsel for the written printed cases and for the oral argument. All the better that they were economically presented, but comprehensively. And also, of course, to those who were involved in preparing the written material. The Board will take time to consider what advice they will humbly tender to Her Majesty. The Court is now adjourned.